So let us begin with the first question. Explaining the importance of parliamentary privileges. Discuss the need for their codification. So if you see, the question is on parliamentary privileges, a previous year area. Discuss the need for that codification. So as you know, the approach should be we would explain about parliamentary privileges first, and then share the importance of parliamentary privileges in our political system, and then discuss the need for their codification. So, and then to conclude, so look at the model flow of the answer. Parliamentary privileges are special rights. So it's a privilege. So it's a special rights, immunities, and exemptions enjoyed by the Parliament as an institution and to its committees and members. So it's a privilege to whom? Privilege means what? It's rights, immunities, and exceptions enjoyed by Parliament as an institution and its committees and its members. So it's a this is a scope. Some privileges are enjoyed by each parliamentary house collectively. So some are collectively enjoyed, such as right to publish reports, exclude strangers from the house proceedings, etc. So these are collectively enjoyed, and some are enjoyed by the members individually. So individually, such as freedom of speech. So here comes the Article 19, freedom of speech in the House and exemption from arrest during parliamentary session. So these are certain privileges and immunities, as we've discussed, immunity. So this is an immunity given to them, special rights to them. They can publish, they can exclude. So broadly, it sums up both collective privileges as well as individual privileges in the opening paragraph. So these privileges are considered important. So now the coming to the question that is important, they protect the freedom of speech of the parliamentarians and insulate them against the litigation. So this privilege insulates against them litigation over matters that might occur in the House of the Parliament. So that's the first thing, protecting the freedom of speech of parliamentarians and insulating them against litigation. Without these privileges, the House can neither maintain authority, dignity, and honor, nor protect their members from obstruction in the discharge of duty. So without this, it's very difficult to maintain the authority, dignity, honor, nor it can protect the members from obstruction in discharging their duty. So this is there to facilitate the duties of parliamentarians. At present, privileges are based on five sources. So now coming to the briefly laying down the sources. One is Article 105 of the Constitution. You know that various laws of the Parliament, the rules of both House of Parliament, parliamentary conventions, and judicial interpretations. So this is about Article 105 of the Parliament Constitution, various laws of the Parliament, rules of both the houses of the Parliament, parliamentary conventions, and judicial interpretations. However, there are no existing laws that codifies all. So there are no existing laws that will codify all the privileges. So just recalling the five sources. One is Article 105 of the Constitution. There are certain laws made by the Parliament, and there's certain rules of both the houses of Parliament. There are certain parliamentary conventions because we have inherited this system from British, and also at large there is judiciary who's interpreting progressively. So, however, there are no existing law codifying all these privileges of the two houses and its members based on the objective guideline on what constitutes a breach of privilege. So this is very vague area. So, need for codification. Now comes the aspect of need for codification of parliamentary privileges. First is to prevent misuse of power. So you have to codify because it has the power to be misused. Codification of privileges will prevent the misuse of the power of the House of Parliament, not to arbitrarily decide when and how breach of privilege occurs. So this will minimize uh, that episode of misuse of power. So then to synergize them with fundamental rights. So without codification, privilege is go against Article 14 and 19 of the Constitution, as they provide absolute freedom. So now they're providing absolute freedom to the speech of MPs without reasonable restriction. Whereas if you see there is a reasonable restriction on Article 19 per se to all. So this gives them absolute freedom. And then clarity and privileges. Codification will give clarity on the exact boundaries that may not be crossed by members on which penal actions may be taken. So this is one area which will provide clarity on the action, and then strengthen the democratic traditions. So it would help in prevention of silent valid criticism by media on the working of the parliament and take actions against the wrongdoers. So this will strengthen our democratic traditions also. For example, PV Narasimha Rao versus CBI case. In this specific case, Supreme Court held that bribe takers who voted against the no confidence motion were immune from prosecution due to their privileges. So those who had taken a bribe, had voted against the no confidence motion were immune to prosecution to privileges. So this would strengthen such traditions, prevention of silencing violent criticism, and then preventing conflict of interest. So codification would prevent conflict of interest, as currently Speaker acts as a compliant advocate and judge with regard to breach of privileges. So it's the Speaker who is acting as a complaint advocate, and so that would prevent the conflict of interest from the Speaker's perspective also. So, however, some experts opine that codification may erode the sovereignty of the Parliament. So, Parliament is supreme in its own sphere. So, this codification is against that. But in fact, Indian Constitution per se, it is Constitution which is supreme, unlike the British Constitution. So, they also have arguments that privileges, if codified, will come within the ambit of judicial scrutiny and determination, which goes against the principle of separation of power. So once you codify certain things, it becomes law, and you can go to judiciary with that. So this going into judiciary for with the codified aspect, it violate the principle of separation of power because it invites judicial scrutiny, and then the National Commission to review the looking of the Constitution, the first and second commissions, and the Press Council of India in their reports have argued for the codification of these privileges because ultimately it's about the misuse thing. Privileges should not be allowed to remain uncertain and vague, and must be invoked in rare circumstances to prevent real obstruction in the legislative function. If there's only a genuine obstruction which is taking place in the functioning of the legislature, then only it must be invoked. But simultaneously, there should be scope for further future adjustment, and the sovereignty of Parliament must be ensured. So these are the balancing points. This will go a long way in strengthening the democratic traditions by allowing genuine criticism. So if you allow genuine criticism to surface in a democracy, so that is you're strengthening the democracy and the right to know of the people of India. So moving on, just to mention the objectives and composition of the National Human Rights Commission. So again, part of the statutory bodies also throw light on its effectiveness. So any body it is judged for its effectiveness, especially in functioning. So objectives and composition, two parts of the question, and also effectiveness, three part totally to the question. So briefly introduce about the NHRC. So as we know, NHRC is a statutory body established in 1993 under the Protection of Human Rights Act of 1993. It's a rights watchdog. Keywords, rights watchdog. Objectives, coming straight to the question, promoting and protecting. So we must promote as well as protect rights related to basically the fundamental rights in one say. You can say life, liberty, equality, dignity of an individual guaranteed by the Constitution, or even those embodied by the international covenants and enforceable by courts. Then to strengthen the institutional arrangements through not only you have to promote and protect, you have to strengthen the institutional arrangements through which human rights issues could be addressed in their entirety in a focused manner, and to look into allegation of excesses. So you must also look into the allegation of excesses if someone has crossed the boundary independently of the government in a manner that would underline government's commitment to protection of human rights. So this is broadly thing, and also you have to spread awareness about human rights because the society are largely not aware of the topic of human rights amongst the masses, and encouraging the efforts of all stakeholders in the field of human rights literacy, not only at national but also at international level too. And if you see, the Act provides for multi-member body. Just to talking about the composition, chairperson is a retired Chief Justice of India or a judge who is recently amended. So it can be a retired CJI or a judge of Supreme Court. And then there are two members or serving as a retired judge of Supreme Court, or serving retired judge of Chief Justice of High Court, three members who have knowledge or practical experience in the in human rights, and there are seven ex officio members who are chairpersons from National Commission of Minorities, such as ST, women, backward classes, NCPCR, and Chief Commissioner for Protection of Disability. So these are the composition as an advisory body. So it is advisory body. The commission has acted as a moral force. As you know, any advisory body would only recommend things, but it's up to the government to accept it. So it has a moral backing upon the state, and some successes can be seen. Now we're talking about effectiveness. We're talking about both success as well as failure. The first part is about the success. It's taken up the cause of marginal sections. As we know, society is hierarchical, not egalitarian. Power is not distributed equally. So the cause of it's taken up the cause of marginalized sections such as prison inmates, mental health patients, bonded laborers. So these are some of the marginalized sections you can talk about. Vulnerable sections, prison inmates, mental health patients, bonded labor, and also improve their conditions. It has kept a watch on fake encounter cases. Always, whenever there is fake encounter or encounter episode, it is NHRC which first arrives to the scene. It has issued guidelines to ensure timely reporting of such reporting of every death in the police station. Now it is also vocal against the draconian laws, no, draconian laws such as the TADA and the POTA. So these are the draconian laws, very vocal against such laws because it has a tendency to violate human rights. And then later these laws were repealed also. It shows the effectiveness of NHRC. And then it can also take suo moto cognizance of rights violation cases based on media reports. So NHRC can do suo moto cognizance. This is a very important thing. For example, NHRC issued a notice to government over the deportation of Rohingya immigrants. So this is how it is working, and expanded the reach by handling over more cases and visiting different states. So handling over more cases and visiting different states to organize open hearing to take cognizance of the problems. While the commission has contributed greatly to human rights protection in India, its effectiveness is curtailed. So while commission is greatly, uh, towards human rights. Now talking about, first we talked about the success. Now we'll talk about the failure, its limitations. So use the word success and use the word limitations. As recommendations are not binding, as we know, it's purely recommendatory in nature, it's not advisory. They're not implemented many times, and NHRC lacks the power to enforce them. So it cannot be enforced. NHRC doesn't have any mechanism of investigation, so it has to depend on the other organizations. So it doesn't have any independent wing such for investigation and is dependent upon other agencies for it. This is one crucial part about its functional autonomy. And then restricted powers to investigate in human rights violation by armed forces. There's definitely armed forces they cannot take up. A large number of grievances go unaddressed. See, this is particularly because of the time limit. And such they cannot investigate the complaint registered after 1 year. So it cannot investigate the complaint registered after 1 year of incident. Improper handling of cases due to lack of required infrastructure is taking place. In an example, inadequate staff, poor funding, etc. These are some of the concerns which have been raised. And then in this context, some have argued that NHRC needs to be revamped to make it more effective and truly a watchdog of human rights violation in the country. So, talk about both the success in terms of giving voice to the voiceless, taking up the cause of marginalized sections, taking up the issue of fake encounters, and draconian laws, ultimately being repealed, and then it also taken up suo motu by its own. It can take up certain things, which is itself very progressive, and it has expanded the reach by handling more cases. And then in limitations, of course, talk about its not binding nature, and then it doesn't have any of its own investigation mechanisms. It has to depend on others, and then it cannot investigate complaints which are registered after 1 year of the incident. So no limitation, uh, because of which many grievances go unreported, and then improper handling of cases due to lack of infrastructure, that is staff, maybe funding. So it's a perennial problem of all agencies. So in this context, some have argued that NHRC needs to be revamped to make it more effective and truly a watchdog of human rights violations in the country. Now, moving on to the significance of preamble of the Constitution. So, can it be amended? So, this is a very uh, important question because already this areas from these questions have already been asked. Significance of the preamble and can it be amended like any other provision of the Constitution? So, write a brief note on the preamble of the Indian Constitution, discuss the significance as second part, and then conclude can be amended and how judiciary has interpreted it over a period of time. So in constitutional answer, there has to be references to articles, commissions, etc. So the term preamble refers to the introduction or preface of the Constitution. As we know, it's a introduction or preface to the Constitution, or it is key to the minds of making understand the minds of the makers of the Constitution. Some call it horoscope. Also, it contains a summary, the essence of the Constitution, and can be referred as an identity card. Also, there are multiple ways of opening up the preamble topic and significance of the preamble of the Indian Constitution. As we know, it embodies the basic philosophy of fundamental values. So, basic philosophy and fundamental values, such as political and moral, on which the Constitution is based. So, basic philosophy that is political as well as the moral on which the Constitution is based, it lays out that philosophy. It contains the grand noble vision of the Constituent Assembly and reflects on the dreams and aspirations of the founding members of the Constitution. So their dreams and their aspirations are we get to know through the Constitution, through the preamble. It reveals the source of identity. That is, we the people. When they say we the people, we get to know the source of authority of the Constitution by mentioning we the people of India. It can be used by it can be used in legal interpretation of the Constitution where the language is ambiguous. So it can also guiding light also for interpretation of the judiciary. It is the soul of the Constitution. It is a yardstick with which one can measure the worth of the Constitution. It is one thing which can directly help in understanding the whole Constitution. It is the preamble. It reflects the nature of Indian state. So ultimately, since it is a phase, it reflects the nature of Indian state and defines the basic characters of the constitution through words like secular, socialistic, republic, etc. So it identifies the objectives. So it identifies the objectives of the constitution by specifying the terms such as justice, liberty, equality, and fraternity. So it identifies the objectives of the constitution by specifying the terms such as liberty, equality, fraternity. So this is about it. And then coming to the amendability of the preamble, as you know, the question of amendability of preamble was started way back. It was raised in historic question on the Bharati judgment. Also, it was argued that preamble cannot be amended. In the earlier Berubari case, Berubari case mentioned that preamble is not can cannot be amended, and it was not part of the constitution, is what Berubari case said. However, in Keshwan the Bharti case, Supreme Court stated that opinion tendered by in the Berubari case was wrong, and the preamble is part of the constitution. So Keshwan the case overturned the Berubari judgment of 1960 and can be amended under Article 368 of the constitution. So article comes up here 368 was while mentioning subject to the condition that no amendment is done to the basic structure. So you can amend it, but you cannot amend it such a way that it does not affect the basic structure as usual. The preamble has been amended only once so far, that is in 1976 42nd Constitutional Amendment Act, which added three new terms, that is socialist, secular, and integrity. So just giving the status of the amendment. There's one amendment, Keshwan the Bharti judgment, Berubari judgment. So these three short paragraphs about the preamble. So moving on, next question is about the significance and the scope of judicial review in India. So we must explain the significance and analyze the scope of judicial review in India. So as you know, going forward with the concept of judicial review, six in the introduction, and then significance, and then the scope. Three question has implicitly two dimensions: significance and analyze the scope. Just give an introduction and conclusion. So judicial review is what define it first. Judicial review is the power of Supreme Court or the higher judiciary, in general High Court, to examine the constitutionality of law or executive orders of both central and state governments. So it will examine the constitutionality of any law or executive order. So if the courts arrive at a conclusion that law is inconsistent, so just it is trying to check whether it is consistent with the constitution or not. So the law is inconsistent with the provisions of the constitution. Such a law is declared unconstitutional. So this is the basic premise of judicial review. Though the term judicial review is nowhere mentioned. So as we know, the term is directly not mentioned in the constitution. Always draw links to the constitution. Uh, the principle of judicial review is encompassed in Article 13. So in Article 13, it encompasses this implicitly. The Article 13 provides that law to be made in such a way that it is in consonance with the norms laid down in the Constitution. So that is about how implicitly judicial review is mentioned in Article 13. Now coming directly to the significance of the judicial review. So significance is that it upholds the constitutional supremacy. Now, since we know that it is trying to be consistent with the constitution, so any law which is being made, so it upholds the supremacy of the constitution. In India, constitution is supreme. So unlike we know that Parliament is supreme in the UK Constitution, in India Constitution is supreme, and this is also part of basic structure. The law to be valid must be in conformity with the constitutional provisions. So thus, the judicial review controls the arbitrary and unjust acts taken on behalf of the executive, and the legislature. So this is the judicial review. Controls this arbitrary and unjust nature, and it also coming to the after constitution talk about the fundamental rights. So it is protects the fundamental rights of the citizens. So this is again a key dimension which we can always talk fundamental rights perspective. From the power of judicial review guarantees the rights accorded by the constitution and are not contravened. Now, federalism is also one of the key feature, which is talked about often. So, it maintains a federal equilibrium. The power of judicial review allows judiciary to invalidate a law if it is inconsistent with the distributive powers laid down in the constitution. So, as we have read yesterday, that federalism is it's a challenge to protect the boundaries. So, in that sense, federalism principle is also this equilibrium is maintained by judiciary, and it invalidates any transgression. For example, the recent 97th amendment, the cooperatives amendment, is struck down. That portion was struck down because Parliament exercised its power on the state list. So it's a particular example, and then provides checks and balances. Since there's judicial review, there is checks and balances. So judiciary is a tool to keep a check on public bodies and render their accountability if their decisions go beyond the constitutional authority. And above all, it upholds the rule of law. The judiciary upholds the rule of law. It ensures that administrative decisions are taken rationally. Since there's a check, now someone is looking after it, there must be rule of law maintained in accordance with the fair procedure and within the powers conferred by the parliament. So coming to the scope of judicial review in India, as we see, the validity of the legislative enactment or an executive order can be challenged. So this validity can be challenged in the Supreme Court or High Court on the following ground. First is, as we saw earlier, that fundamental rights angle. So fundamental, if it infringes on the fundamental rights of citizens, and then if it's outside the competence of the authority, as we saw in the 97th Amendment being struck down, partially being struck down, and then it is repugnant to the provisions of the Constitution. Same thing. This is the scope actually. Well, unlike the scope, Indian Constitution provides for the procedures established by law. So as we know, this we have picked up from the Japanese Constitution, procedure established by law and not due process of law, as in USA. Under the procedure established by law, Supreme Court, while determining the constitutionality of a law, examines only whether the law is validly enacted. It only sees whether the law is validly enacted. It's not expected to go into the reasonability, suitability, and the policy implications, which is actually the holistic requirement. Checking the reason, checking the suitability, checking the policy implications. So that will be the domain of the legislature, if you see in one sense, for under the due process of law. However, the scope of judicial review has been expanded. In Maneka Gandhi case of 1978, a famous case where Supreme Court observed that the procedure established by law does not mean any arbitrary procedure laid down by the parliament. Exactly, this procedure established by law does not necessarily mean any arbitrary procedure laid down by the parliament, but it must be interpreted in the lines of due process. So that is also taken care. The procedure should not be don't become arbitrary. So in this context, it can be said that India has attempted to strike a balance between judicial supremacy, because there is judicial review. At the same time, there's limitations on that, and parliamentary supremacy. So this is a key line of thought or conclusion. We were trying to end with both the basic structures of the constitution, where our constitution is trying to do a fine balance. So three parts: opening up of judicial review, significance of judicial review, and then the scope of judicial review, and a small conclusion. So this question is a broad question, right? What are the foundational principles on which our constitution is based? Why do you think it was important to codify them in the form of a written document? So, as we know that we have a written constitution, certain foundational principles on which are it's based. So, briefly define the constitution and mention the foundational principles. This will be the first part, and then analyze the reasons why it was necessitated to codify at that time, back then. So, we must always go back then, put in their shoes, and conclude a constitution is a body of fundamental principles according to which the state is constituted and governed. So, this is the basic law of the land. It's the supreme law of the country. It determines the rights of the citizens, as we saw, right, fundamental rights. We have a chapter, powers of the government, and how it should function. So these are the. It also has checks and balances. The values that inspired and guided the freedom struggle. So we have a historical, long drawn freedom struggle, which motivated the entire world. Values that inspired and guided the freedom struggle and were in turn nurtured by it form the foundation of the Indian Constitution. So these values are embedded in the preamble. So where we can see these values, they can be found in the preface, the horoscope, were in the preamble and guide the provisions of the Constitution. The foundational principles that are the basis of the Constitution are as follows. First is sovereignty. So citizens of the country, through their representatives, exercise the power to take decisions on internal as well as external matters. So it's very important that as a country, we are having that freedom to take our own decisions, whether be it internal as well as external, without any influence. We must not be influenced or swayed. This is a core aspect of sovereignty. And then social justice. Framers of Indian Constitution were aware of the existing social cleavages back then, and social disparities, be it in terms of caste, be it in religion, poverty, illiteracy. These were the ills which are present in the society. So thus they made adequate provisions for socio-economic and political equality for all citizens. Especially Ambedkar made the provision for affirmative action, reservation for SCs and STs. He ensured that it was there in the constitution. And then secularism. So India being multi-diverse country, citizens have their freedom to follow any religion, office, or choice, and there's no official religion of the state. We are a secular country with no official religion of the state. The government should also treat all religious beliefs practiced with equal respect. We must respect the faith. So that is the secular aspect. Secularism is also about respecting everyone's faith. State is trying to respect. So then respect for diversity and minority rights. So individuals belonging to the cultural communities, and every community has its own values. They have their own shared belief systems, traditions, customs, languages, which are shared by its members. So that diversity, which is unique to India, and we cherish the diversity, that should be respected. Indian constitution respects the cultural diversity and also provisions for protection of linguistic and you know religious minorities in terms of Article 29 and 30. Coming to parliamentary democracy, it has three basic features. The parliamentary democracy itself guarantees certain principles that executive is responsible to the legislature, which is the Lok Sabha, and then democratic basis of the lower house, which is directly representation. They are elected directly, and then ultimate control of the lower house in legislative and financial matters. Since they are elected from the people directly, they have more control in terms of money bill and such things. So giving more say to the people who are directly elected than people who are coming indirectly from the Rajya Sabha. So this is three key characteristics of features of parliamentary democracy, where executive is held responsible in a way bringing accountability, and then democratic basis is that because they're elected themselves, and then giving more powers to them in terms of money bill, etc., having say. And then liberty, individual Indian liberalism strikes a balance between the rights of individuals and community values. This must always keep in mind that Indian liberalism, it strikes a balance between the rights of individuals and the community values, because our constitution protects both individual as well as community rights. So that is where liberalism strikes a balance, unlike Western liberalism, where individual rights are more cherished. And coming to equality, all citizens are equal before the law of the land. Further, government should ensure equal opportunities. So this is very crucial. Giving equal opportunities for all citizens is also a way of sustainable development. Ensuring equal opportunities for all citizens. And coming to fraternity, this is a feeling of brotherhood, and not treating fellow citizens as inferior. So this is about fraternity, that there is a feeling of brotherhood and not treating the fellow citizen as inferior. So this is about the core things which I mentioned in the preamble. Now coming to the second part of the question, that the following reasons which were necessitated for the codification of the written document back then. Just go back then, that a written constitution will give more clarity, would help in clearly defining the structure and functions of the state and its organs, and proclaiming its basic principles. So that is why establishing governing institutions and regulating the relationship. So written constitution provides such clarity. There will be no vagueness. The executive lacks the authority to alter the written constitution without undertaking an arduous process of amending the constitution. So written constitution, has to go to the rigorous process of amendment. It cannot be easily amended. So a procedure that is specified in the constitution itself. So this ensures that constitution, which is supreme, so amending the constitution, no, is a supreme. It's a supreme thing. And then in a federal setup, a written constitution is required. So as we know, we are a federation. So a written constitution is a basic feature of a federal setup, where powers are delineated between the two set of polities. In a federal setup, a written constitution is required, as it helps clearly specifying the power sharing agreement. So there's element of power sharing between both the states at various levels of government. Moreover, the provisions that affect the distribution of powers between the center and states can be amended only with the consent. So it can be amended only with the consent of at least half of the states. So this is also an aspect where consent, widespread consultation is already been implemented to take into account the regional aspirations. A written constitution helps. So a written constitution helps in laying down limits. So it helps in laying down limits, as we know, on the powers of the government. It's a limited government. In one sense, this was the question, and specifying certain fundamental rights of citizens that cannot be transferred. So the trespass, because fundamental right, basic structure, doctrine, all these limits the powers. So it generates a degree of trust and coordination that is necessary for different sections of the society to live in harmony. So this was about the aspect of generating trust and coordination that is necessary for different sections of society to live in harmony. So very basic question, foundation principles mentioned in the preamble: sovereignty, social justice, secularism, respect for diversity and minority rights, parliamentary democracy, the aspects of liberty, equality, fraternity, those core values mentioned, and then the need for codification, written constitution, defining it clearly, giving clarity, federal aspect, and then amendment aspect. So limiting the spheres of the government. So also generating trust. So this is an important perspective. So next question is on the concept of federalism, as we discussed yesterday also, and also mentioned the key features of federalism in India. So what do you understand by federalism? Key features of federalism in India specifically, and you know, and concluded by uniqueness of Indian federalism. So federalism is what a system of government in which the power is divided between two set of polities. It may be central and also a regional power, regional government. So there will be a national government as well as there will be a local regional government. Constitution specifies the power sharing agreement between different levels of government, different tiers of government for the same citizens, but each have its different tiers is there of government, but each has its own independent jurisdiction. Each has its own independent jurisdiction in specific matters of legislation, taxation, and administration. So this we must always keep in mind that each has its own independent jurisdiction in terms of certain issues like lawmaking. They have their own spheres such as central union list, state list, and concurrent list. Taxation, the powers have been divided. Administration, also it has been divided. So even though constitution declares India as union of states, so what does it say of constitutional federalism? That we have to mention. Even though constitution is telling that it is a union of states, the Indian union is based on the principles of federalism. There are some of the features as coming to the question or dual polity. Federalism has dual polity. Establishes dual polity consisting of the union government at the center and state governments at the regional level. First thing, and then the division of power. So division of power is a key feature because the constitution, written constitution, especially clearly demarcates the subjects under the exclusive domain of the union and those under the states, and prescribes the limit within which they must operate. And then bicameralism. As we know, bicameralism has been provided. We have Lok Sabha and Rajya Sabha. Bicameralism ensures the state's representation. Also, the constitution provides for bicameral legislature consisting of upper house, that is Rajya Sabha, and lower house, that is Lok Sabha. Rajya Sabha represents the states of Indian Federation. So Rajya Sabha represents the states of Indian Federation, while the Lok Sabha represents people of India as a whole. So this is the core role of Rajya Sabha, where it is representing states in the parliament, a core aspect of federation, and then supremacy of the constitution. So in a federal setup, the constitution is supreme, not either of the spheres. The constitution is the highest law of the land, and laws. That's why we have to have a written constitution, and then laws enacted by the center and states must conform to its provisions. So these are the something about the basic constitution, and then rigid constitution. The federal features of the constitution, the federal features of the constitution, that is center-state relation, judicial organization. So this federal feature, the rigid constitution, the federal provisions of the constitution, that is center-state relations, judicial organization cannot be unilaterally changed by one level of government because constitution is rigid. It cannot change it on its will. So one level cannot change it unilaterally. So it can be amended only with the joint action of the center and the state governments. So as we can recall, the provision of requiring ratification of half of the states, and then to all this there's a check of judiciary. Independence of judiciary. The Constitution establishes an independent judiciary to protect the supremacy of the Constitution by exercising the power of judicial review. As we've seen judicial review earlier, also that's a core feature of protecting the respecting the federal equilibrium, federal boundaries, and it also settles the dispute. As we know, Supreme Court under Article 131 has its original jurisdiction to settle disputes between center and state. So there's an independent judiciary to do this. So thus, Indian Constitution has created a strong central government to stem disintegration and bring about socio-political change. So to keep the unity and integrity of the nation, a strong center is proposed, and then it has some unique features like power of the center to unilaterally change the area boundary, name of the state, process of appointment of governor, a single constitution, single citizenship, no equality of state representation in Rajya Sabha done based on population, and then emergency provisions, single citizenship, all in the services. These are all the aberrations to the federalism principle. So it shows that the constitution is unitary. For example, I'll just repeat. So, what are the features which shows that Indian Constitution is more unitary than federal? One is the power of center to unilaterally take certain decisions, such as changing the area boundary name, the process of appointment of governor. Only center is as a role. We have a single constitution because in US we have the double constitution. State also has its own constitution, and then single citizenship accordingly. No equality of states in representative Rajya Sabha compared with the Senate, where all the states have equal representation, and then emergency provisions uh, are there. In emergency, almost constitution becomes unitary. There is single citizenship, and there is all India services. So all India services ensure uniformity in governance administration. So these are the unitary features. The above we discussed are federal features such as dual polity, written constitution, division of power, bicameralism, supremacy of the constitution, constitution being rigid, and then independence of judiciary. So we talked about all the aspects. So in SR Bommai case of 1994, Supreme Court laid down that constitution is federal, and then the constitution and characterize this federalism as a basic feature of the constitution. So Indian federation has been deemed as cooperative federalism by certain constitutional experts, political thinkers, to meet its peculiar needs. Thus, Indian federal system has dual objectives, that is to safeguard and promote unity of the country and accommodate regional diversity. So these are the core objectives. You have to safeguard the unity of the country as well. That's why you have to become unitary in some sense, and also at the same time by providing autonomy to the regional sections, you are accommodating the regional diversity. So this is about the question of federalism, very important.